All right, we are recording now. So in today's session, again, I wanted to review two particular elements of the T visa, the present on account of element and the hardship element of the T visa. We've seen USCIS apply increased scrutiny to these elements. So we think it's a good time to review the legal requirements of these and talk about how to best frame arguments for T visas on these elements. I also know that many teams have gotten RFEs and have been working diligently on those RFEs. So also wanted to spend some time talking about how to structure an RFE response, what evidence to gather, and best practices for RFEs. We also wanted to talk about best practices for casework during COVID. Representing trafficking survivors is already really difficult, and the pandemic definitely presents unique challenges to working with survivors of trafficking who are experiencing ongoing trauma. So wanted to also share some best practices on how to connect with your clients given the current situation. And then lastly, I wanted to open it up for a group discussion of strategies and challenges, because I know many of you have been working on RFEs and have found things that work. And I think it would be great if you're able to share those strategies with your colleagues. So with that, we will go ahead and get started. Again, starting first with the present on account of requirement. And I want to focus on where we've seen the most scrutiny on this element. Is on the client's continuing presence or current presence in the U.S. So recently we have seen that in cases where the client has escaped their trafficking more than 3 to 5 years ago, USCIS has applied or has questioned whether or not the applicant's current presence is a result of the trafficking victimization. And their rationale is based in the T visa eligibility requirements in the INA. So I have here the language from the INA, and you'll see that the trafficking requirement is that the applicant is or has been a victim of a severe form of trafficking in persons. And then the presence requirement is phrased only in the present tense. So based on this language, USCIS is saying that because this is phrased in the present tense, they have to look to the applicant's current presence in the U.S. and make sure that the applicant's current presence is related to their trafficking victimization, or they're here on account of their trafficking victimization. The regulations provide a little bit more information on how we assess this requirement and some factors that USCIS will look at, including when the applicant escaped their trafficker, activities they've undertaken since the time of their trafficking to deal with the consequences of having been a victim of trafficking, and the applicant's ability to leave the U.S. And all of those factors have to relate back to the trafficking as their reason to not, or the reason for their current presence. And I actually, apologies, wanted to pause here because I realized I forgot to explain some ways to participate. Because I do want, if folks have questions as we're going through, I do want you to be able to ask questions and provide insights that you may have. So you are all welcome to come off of mute at any time and jump in. And then there is also a chat function as well, so please do feel free to use the chat as well to send a message to everyone or to share your experience with these issues. So. Thank you for letting me go on that brief side note or tangent. Okay, so then back to the current present. So this is the legal standard that USCIS uses when they are assessing whether or not an applicant is currently present in the U.S. on account of their trafficking. Based on this standard, there are several different arguments that we find can be helpful in supporting that your client is currently present in the U.S. on account of their trafficking victimization. And these arguments can be raised both in the initial T visa filing and then at the RFE stage as well. So some particular arguments that we have found that have been successful include the arguments listed here. So fear of retaliation from trafficker in home country. To make this argument successful, we asked our clients questions around the last time they had contact with their trafficker, if their trafficker has continued to reach out to them or continue to threaten them. And it doesn't necessarily have to be that the trafficker is trying to re-victimize them or to gain control over them again. But even if the trafficker is threatening other kinds of harm in retaliation for escaping or in retaliation for reporting to law enforcement. Another argument that can be successful to show the applicant's current presence is their recent realization of victimization. So as many of you know, survivors of trafficking don't immediately self-identify as a survivor of trafficking. And most of our clients didn't know they were a victim of trafficking until they spoke with an attorney. So that's something that we describe in the client supplemental statement, that they didn't realize because of the manipulation of their trafficker, they didn't know that they were a victim until they spoke with an attorney, and they didn't know they were eligible for a T visa until they spoke with an attorney. Another argument is that they're continuing to experience adverse consequences of their trafficking. So this is going to relate to the mental health, any mental health issues stemming from the trafficking, any financial difficulties stemming from the trafficking. But these have to be pretty squarely linked to the trafficking victimization to support that the applicant is still currently present in the U.S. on account of the trafficking. Another argument is that the client is accessing trafficking-specific support services in the U.S., and that can include social services, it can include legal services. In many of our cases, the client is working with Freedom from Trafficking, a social service provider who provides case management, and the fact that the client is taking advantage of these trafficking-specific resources that wouldn't be available to them in their home country demonstrates that they're currently present in the U.S. On account of the trafficking. The next argument is that the client doesn't have the resources to leave the U.S. Again, this needs to be linked to the trafficking victimization, so it could be that trafficker has confiscated their passport and they still don't have a passport or are unable to get a passport. It could be that, because of the financial situation from the trafficking, they don't have the ability to pay for travel outside of the U.S. The next argument is that that client is continuing to cooperate with law enforcement, so their presence is to assist with the law enforcement investigation. And then other arguments include accessing legal remedies or protection in the U.S. legal system. So for a victim of sex trafficking, we've argued that she is present because she is accessing the legal remedy of vacatur in Illinois to vacate her unjust prostitution conviction. And other forms of protection of the U.S. legal system include an order of protection. So if the client has recently received an order of protection, they're receiving protection from the U.S. legal system that they wouldn't be able to get in their home country. So they are eligible for, or they are currently present to receive that protection. The biggest area where we see conflict here is when there's extensive detail about the client's family ties in the U.S. USCIS has, in some cases, said the client is no longer present on account of the trafficking and instead is present for family unification purposes and not the trafficking. So when we do our initial T visa filings and RFEs, we do have to be careful about the extent to which we talk about family members and children in the U.S. That is a little, that can sometimes feel unnatural because in many other areas of immigration law, connection to family in the U.S. and having U.S. citizen children is a positive factor, but in the T visa context, it's something that can undermine the present on account of issue. So before I start working on an RFE related to present on account of, or a T visa case where I think that this could be an issue, I like to revisit two different cases, matter of DAA and matter of JHS. I know these are both cases that I've shared with many of the pro bono teams working on RFEs, and I think comparing these two cases really helps understand what factors USCIS is looking for when they're adjudicating the present on account of requirement of the T visa. So matter of DAA is a case where on appeal, the AAO found that the applicant was indeed present on account of, and in JHS, the AAO found that the applicant was not present on account of. And the biggest differences had to do with the adverse consequences that the client was suffering from as a result of the trafficking. Both clients had escaped their trafficker more than a decade prior. So at first glance, the cases seem similar, but once reading through the decisions, I think we can pick up some tips on how to frame present on account of RFEs and how to frame affidavits, both the initial and supplemental affidavits on the present on account of issue. So matter of DAA is a case that involved an H-2B visa, where the client, after entering on the H-2B visa, was trafficked, and the client had significant mental health diagnoses stemming from the trafficking, including PTSD, and the applicant's current financial instability was directly related to the trafficking because they had to pay fees to try to sort out their work visa, and they were unable to find employment because of their trafficking victimization. In that case, the AAO found that that applicant was present on account of because they were still dealing with these very severe consequences of having been a victim of trafficking. In matter of JHS, we saw something different, where the client, in their personal statement, talked about some of the adverse consequences, but then also admitted that since the deportation of their trafficker, their life had improved greatly, and that undermined the present on account of requirement of the T visa. So that case involved a domestic violence human trafficking situation, where again the client, at least as far as the AAO could tell, had recovered from the trafficking and was doing better since the deportation of her trafficker. And USCIS found that even though she was facing financial instability, it wasn't related to her trafficking. It was related to other causes. So I think the big lesson from comparing these two cases is how we frame our arguments, and always linking back to how their current situation is a direct result of their trafficking victimization. And they wouldn't be in this situation but for their trafficking. So before I move on to hardship, I do want to give folks a chance to ask questions about this element. Later on, we'll talk a little bit more about what evidence to submit. But does anyone have any questions on the legal requirements of the present on account of element and arguments that we can show to show the client's current presence?
Erica, this is Shireen. Can you hear me?
Yeah.
Oh.
There are two people spoke at once, but
go ahead. Whoever was speaking,
Shireen.
I can go next. Oh, thanks.
No,
Sorry.
Shireen, please go ahead.
Thanks. No, I just have a quick question about the if we have a client who is, at the time we filed the application was speaking to the FBI and then no further contact since then. There were 2 interviews. Is it in any way beneficial to go back to the FBI and ask them if their investigation is closed, or with the hope, obviously, that they haven't actually closed it and we can say in good faith that it is still open and she's willing to cooperate? I don't know if that's anything we can get.
Yeah, that's a really good question. So I think, and the first thing that reminded me of is an important clarification is that the present on account of requirement is actually at the time of filing the TVisa application and not at the time of the RFE. That said, a lot of the intervening events are helpful. So in that case, I think it would be helpful to highlight that, around the time she filed the TVisa, she was cooperating with law enforcement. We can always reach back out to the FBI and see if they're still investigating. Usually if there's been some time passed since the last interview, we can take that as an indication that they're not opening an investigation, but we can always reach out to see if they need more information.
Okay, I think what we had was there were 2 interviews and the application wasn't filed until about 7 months afterwards. So I think because we were applying for other things in the meantime. So I think that's the issue we have. But thank you.
Yeah, and we could. I'd be happy to talk more about this specific case separately as well. Yeah.
Thank you.
Hey, Erica, this is Tim and Aon. First of all, thanks so much for putting this together. It's super helpful. And one question I had was about the argument that the individual doesn't have resources to leave the U.S. I know that obviously a number of countries have restrictions right now on entering as a result of the pandemic. Is that an argument worth making here? That, like Colombia, for example, in the case of my client, I believe has restrictions on people coming in. Is that worth arguing?
So I would be inclined to not include that as an argument for a few reasons. The first being, well, hopefully you would get a decision within the next few months. And while I know that COVID will unfortunately be with us for a long time, there is going to be a point where that's no longer true. And then my fear is that USCIS would then say she's not present on account of the trafficking, but because of the COVID pandemic. So I fear it could do more to undermine the present on account of requirement.
Got it. Okay. Yeah. Thanks. That makes sense.
Yeah. So any other questions on present on account of before we briefly turn to hardship?
Erica, just one other, those 2 cases you cited, would it make sense for us in our responses to actually cite the one that's beneficial for us?
Yeah, absolutely. And I would say you can even cite both, citing why your case is similar to DAA and why your case is, distinguish your case from matter of JHS.
Okay, thanks.
Yeah, great question. Okay. So the next area where we've seen some more increased scrutiny is on the hardship element, not to the same extent as the present on account of, but again, this is like a very specific area of the TVisa framework that is different from other areas of immigration law. So one of the big differences and important things to remember is that when USCIS is adjudicating hardship for a T visa, they're looking solely at hardship to the applicant and not to any family members. And that's different than many other areas of immigration law, so it's important to keep that in mind because the way we frame hardship for a T visa is going to be different than a lot of other cases. So the regulations for the T visa include several different specific factors, many of them related to the trafficking victimization. What we have found is that USCIS tends to prioritize the factors that are related to the trafficking victimization as opposed to other factors about conditions in home country that aren't necessarily related to the applicant's status as a victim of human trafficking. So for this element, we generally recommend that, at least in the initial T visa filing, that when you make your arguments for hardship, that you focus on factors that are related to the specific factors listed for the T visa, and factors that are related to the trafficking victimization. And that when you write the legal argument for hardship, that you're citing to these specific factors in the regulations. The same is true for the RFE stage. At the RFE stage, you may bring in some more evidence and more factors, but again, the priority should be on the trafficking specific factors. If you take a close look at the regulations, technically USCIS can consider factors not related to the trafficking, but it is discretionary, and we find that they, again, are giving priority to those trafficking specific factors. And then, something else to keep in mind is how the hardship and the present on account of element interact. Citing to a hardship factor that isn't related to the trafficking but is related to something else does have the potential to undermine the present on account of element. So for example, citing to a medical issue that's not related to the trafficking victimization, or citing to, lack of family, or like the separation from family when not related to the trafficking, that could, again, undermine the present on account of, where USCIS would say the applicant is not present on account of the trafficking, but instead to get medical care for an unrelated issue, or for the purposes of family unity. The one exception to this last piece of the family unity that I would make would be if the particular family member has a connection to the trafficker. So the case I'm thinking about is one of the pro bono cases where the trafficker is the father of the client's child, and because of that, the survivor wouldn't be able to leave with child because trafficker wouldn't allow the child to leave, or at least that was before the child was 18. So I think generally we try not to focus on those family ties and hardship, but the one exception might be a situation where that other family member is a child of traffickers. And any questions on hardship before we move to responding to RFEs? Okay. So again, and this is a part where I would definitely love to hear from all of you, because I know that you are all working so hard on your RFEs. Unfortunately, we've seen increased scrutiny from USCIS, so we have seen an increase in the number of RFEs. So I want to talk through how to identify pieces of evidence, how to gather evidence, and then submitting the cover letter in response. But again, feel free to jump in by coming off of mute or by using the chat function as well. Okay, so the very first step when you're responding to an RFE, and I actually think like a repeated step throughout the process, is turning back to that RFE document. So I've included here a sample of what's often included in the present on account of RFEs. Yes, I'm sorry. I think so. Okay. Apologies. I think someone was trying to join, and I hope they were able to get in. So yes, I've included here a sample of what's in the present on account of RFE, and where they've listed out what kinds of evidence they're looking for. And it's really important both at the outset of planning for the RFE, and then also as you continue to work on the RFE, to keep turning back to this document, because it's really important that we are responsive to what the RFE has requested. So again, this is the language from the present on account of RFE, where they've ask for, a document from a mental health provider or a medical provider. And then, they always have this any other consideration or any other piece of evidence that will credibly establish, whatever that issue is that they're looking at. I've included a list here. This list is, of course, not exhaustive. And the evidence that we include will depend on the case and the particular client situation. USCIS uses an any credible evidence standard, so that really does give us a lot of leeway in what we submit. It's important to include what they're asking for, and then if there's a case where there's a certain piece of evidence that may not be available, it's important to explain why that piece of evidence is available, both in the client's affidavit and in the attorney's cover letter. So some examples of documents to include are, and this first one is definitely a mandatory, and in all cases, we're going to include a supplemental statement from the client, basically responding to the RFE, so for the present on account of, describing the continuing impacts of their trafficking victimization, the need for services, recent realization of victimization, and then any recent threats or contact from trafficker, and then any other situations that make sense in the client's condition or in the client's situation. Another big piece of evidence that we find to be very helpful is an evaluation from a mental health provider describing any mental health conditions stemming from the trafficking victimization, which can include PTSD, depression, anxiety. And that letter, again, is what distinguishes between DAA and JHS in showing the ongoing severe impacts of the trafficking victimization. We also like to include a letter from the client's social worker describing the services that they're receiving. And that's something that can be helpful both for present on account of and hardship, because they're present to receive those services, and they would face hardship if removed because they would no longer be able to receive those services. Sometimes we also like to include letters from family members or friends when they can substantiate any recent threats from trafficker or threats of retaliation. Police reports and orders of protection can also be helpful in showing ongoing threats by trafficker to the applicant. Medical report, again, only if medical issues are arising from trafficking. And then some secondary sources that we like to include is research on the lack of self-identification among trafficking survivors. There's a really great Polaris Project report that describes all of the reasons why, why survivors of trafficking don't come forward right away. And I think that's a really great piece of evidence that I am happy to share with everyone to include. And then again, reports on conditions in home country and the lack of services in home country. Primarily, that's going to come from the Trafficking in Persons report, which you likely included in your initial filing. They did, just about a week or two ago, released the new TIP report. So I do encourage you to look up the TIP report for your client's home country and see if the language has changed, see if there's anything helpful in the new report to show even a worsening of the availability of services. And I do want to highlight here something that I found helpful in kind of organizing all of this evidence for USCIS is to include an annotated index. So I know several of you have worked on asylum cases, and I know that's the practice, or that tends to be the practice with asylum cases, to provide an annotated index. I think especially at the RFE stage, an annotated index with the quotes and key information from all of the sources except for the client statement, because everything in the client statement is going to be an important piece of information. I think that's a good way to quickly and easily direct adjudicators to the new evidence that you're submitting. In addition to all of the evidence that you're submitting, the RFE response should also have a cover letter similar to the cover letter that you submitted with the initial T visa filing. And this cover letter should include a detailed legal argument explaining why the client meets the eligibility the eligibility criteria subject that are identified in the RFE. And again, it's important to address every issue identified by the RFE. So that USCIS doesn't come back and say, like client addressed X and Y, but didn't address Z. And again, that's why I like to, throughout the process, continue to refer back to the initial RFE. It's very easy to, read it and then start working and, forget to go back to it. And I think that's always a helpful thing to revisit. I also like to provide the adjudicator with a roadmap previously submitted evidence and then the new evidence. And I do that kind of like in the introduction of the cover letter. And then throughout providing pin sites to the evidence and really I think that helps incorporate the evidence into the legal argument. The job of the cover letter really is to make it as easy as possible for the adjudicator because, they're reading lots of documents and I don't necessarily expect them to always read through every single piece of supporting evidence. So the cover letter really is to direct the adjudicator to the most relevant information, the strongest legal arguments, and to make it as easy as possible for the adjudicator to identify where they need to look in the supplemental documents. We at NIJC are happy to review your cover letters and the client affidavits and all of the documents. I do ask that you send them to us at least 10 business days prior to filing the RFE, both to give us time to review and then also to give you time to make any necessary changes with the client. Especially with COVID, it may be more difficult to get in touch with clients. So this will give a little bit more of a buffer to make sure everything can be finalized before submitting the RFE. I also do want to talk a little bit about the NTA memo and how to address this in the RFE stage in the cover letter. So this is something, again, this is for folks working on RFEs and not for initial T visa filings. So in November of 2018, USCIS stated that they would begin applying the notice to appear memo to T applications. That notice to appear NTA memo basically, the notice to appear is the charging document that the government uses to commence removal proceedings against a non-citizen. So because of this new policy memo, if a T application is denied, the applicant can be placed in removal proceedings. This is again client specific, but in most cases, we don't want the client placed in removal proceedings because it puts them at risk of deportation. Some clients may have relief available to them in proceedings, and we can talk if you have a question about your specific case. We can have conversations offline or at a later time about your specific case. But in most cases, we would want to include a discretionary argument that USCIS should not issue an NTA to the client. And again, this argument is going to be based on their status as a survivor of human trafficking and not based on family ties because of the potential for that to undermine the presence element. I do also have sample language on the NTA memo that I'm happy to share as you draft your cover letters. Okay, so before we move to working with clients during COVID, any questions on how to respond to RFEs or evidence to include in RFEs?
Erica, one question. This notion about the NTA memo seems a little bit concerning. Obviously, the last thing we would want is to somehow, do more harm than good. Are we seeing instances where clients are actually subject to removal?
So We have, let's see, we have not had a T case be denied while there's not some other pending form of relief. So USCIS wouldn't issue, or they in their guidance, they say they generally won't issue an NTA while an appeal is still pending of the T visa. And they've also said that they would try to adjudicate all other forms of relief. I'm aware of U visa cases where a U visa has been denied and the client has been referred to proceedings. And that is indeed very troubling, especially because this policy wasn't in place when people were initially applying. And this, I think, potentially applies to some of your clients as well, where this policy wasn't in place when they first started working on their T visa. Yeah, I agree. It's definitely very troubling, and that's why we want to include this discretionary argument. And we'll talk more about this at a later point in the presentation. But if a client's case is denied, we do ask that you contact us immediately so we can assess other forms of relief. Many clients may be eligible for other forms of relief, whether that's a U visa or something else. So we would want to see what other forms of relief the client has available to them, and we would have to work pretty quickly once a case is denied. Does that answer your question?
Yeah, that's helpful. And it seems like despite this risk, you guys are advising that we still kind of proceed with this. I mean, as you pointed out, we've already filed these, and we did so, but unfortunately before this policy came out. So maybe at this point, even if we wanted to take a conservative approach, there really isn't much we could do to kind of mitigate this risk, right, other than kind of present this discretionary statement in our briefs.
Right, exactly. Yeah, so for cases that have already been filed and you've gotten the request for evidence, if no response is submitted to that request for evidence, the case would be denied, and that would put the applicant at risk of being issued an NTA since the case has already been filed. For folks that haven't filed the initial T visa yet, it is a risk to talk through with the client and make sure that they're aware of that risk in filing for the T visa.
Got it. Thanks.
Okay. So I also wanted to spend some time talking about casework during COVID. Again, our clients are facing many unique challenges because of their trafficking victimization, and unfortunately, many of those challenges have gotten worse during the COVID pandemic. I wanted to highlight a few resources from NIJC. If you go to our webpage in the For Attorneys tab and search COVID-19, we do have some guidance on, operating status of various agencies and resources. So that is a great place to go for some more information. As we work with clients, we've had to change how we're working with our clients because of COVID and our inability to meet with clients in person. So I think, the very first starting point is that many of our clients are facing significant anxiety, fear, and distress because of COVID. They likely have higher social service needs, and they're also left out of a lot of the resources for a lot of government resources responding to COVID. So, I do try my best when I talk with clients to acknowledge that this is a really hard time and a really hard time to be working on an RFE. This next point is, of course, going to depend on the client's comfort and their ability to do this. One of the challenges of doing affidavits on the phone is that I can't see my client's reaction, and I also can't see what's around them. So if possible, we recommend that you use video technology because it makes it a little bit more interactive, and it may be easier to engage clients that way. However, I recognize that many of our clients don't have the resources or don't have the tech savvy to be able to do video calls. But again, noting this challenge of that we can't see what's around our clients. I try my best to check in with clients to assess confidentiality and the space around them. I find that it's best. I like to call my client to schedule a meeting as opposed to just calling and doing the meeting, so that they can make sure that they've set the time aside, and so that I can prepare them and say, we're going to talk about things that may be very difficult to talk about. And it's important that you're in a space where you can talk freely. Will you be able to find that space during that time? Because again, recognizing that our clients, if they're calling us from home, maybe with family members who don't know about their trafficking victimization, or for other reasons, may not be in a safe space at home. I've been trying to keep my meetings shorter because it's definitely hard to be on the phone with a client for a long time, and they also may have some other disruptions, including just as many of you may have family members and children at home that they're caring for. And then in terms of documents, I still am having clients sign. We can submit photocopies of signatures, but you do have to keep the original on file if USCIS were to ever request it. So at that point, we still need to get the original back from the client. So I have been mailing clients documents to sign and giving them a way to mail it back to me. But again, before doing that, confirming that it's safe for them to receive mail at their home, and that they have safe access to phone, text, email, mail, FedEx, or however you send documents. For email, I like to ask, does anyone else have access to this email account if I send you something? Just to make sure, especially if you're sending details about their trafficking or something like that, making sure that it is a safe place to send those documents. NIJC does have more guidance online for working with clients remotely, so I also recommend that you check out that resource. And then, as many of you know, USCIS has, in response to COVID, is giving us an extension on RFEs. So for any RFE issued between March 1st and September 11th, USCIS will consider a response received within 60 calendar days before taking any action. But a cautious interpretation of that within 60 days means that we would want the response to be received at VSC no later than the 59th day. So just, as you're calendaring these deadlines, keep that in mind, that it's the 59th day and not the 60th day. While this extension is helpful to gather additional evidence, especially because it's hard to get evidence right now, you also don't have to wait until the 59th day to submit it. So while we do encourage you to use the extension, if it will help gather evidence, you don't have to, and you can also submit it earlier than that 59th day deadline. Because again, USCIS isn't going to be able to adjudicate the case until they get the response. So taking that extension does increase the time that it will take to get a final decision on the case. And then on your end, as you all have been doing, it's important to ensure timely access to mail and voicemail in the event that you get mail from USCIS or contact from your client. And now more than ever, it's important that we're staying in contact with our clients and reminding them to let us know about any documents that they receive, and to make sure that they give their attorney up-to-date contact information. And then if you, after you submit the RFE response, once you receive a decision, you should contact NIJC immediately. If the client's case is approved, we would then want to coordinate next steps of referring them for additional social services, and then starting the process for the green card application, and closing out their case. And then, of course, if the case is denied, the appeal time frame is very short. So it's important that we are aware right away, so that if the client does want to appeal, they're informed of their right to appeal and the timeline for that. Okay, so I do want to, we have about 10 minutes left. I want to open it up for any other questions, as well as discussions. What challenges are you having both in responding to RFEs, working with clients during COVID, and what strategies have you all found that have worked well in communicating with and working with clients during COVID?
Hey, Erica, this is Shireen. Have you experienced RFEs on the question regarding the waiver of inadmissibility? Because we have that situation.
Yes, so we have, yes, we have gotten RFEs on the waiver of inadmissibility. I will say it does seem like, in many cases, they're doing the RFE to like clarify which grounds of inadmissibility are being, or they found apply and you're requesting the waiver for. We recently had a TVISA approval where in the waiver, they actually listed out the grounds of inadmissibility. So it's important that we're definitely including all of the grounds that apply and addressing them again at the RFE stage.
Okay, so you think it might just simply be that this one was the failure to obtain, obtaining without parole or permission. So we just need to focus on that, even though I don't think we specifically referenced it when we applied.
Okay, Shireen, maybe we can chat offline and I can take a look at the initial filing just to make sure that there was a waiver filed and everything was addressed. But this could also be a way of them clarifying which grounds of inadmissibility apply. And in that case, I would argue like it was in your case, it's clearly incident to her trafficking. So it still needs to be addressed in the RFE, but it's not going to be a whole lot of like getting new evidence or documentation for it.
Perfect. That's what I want to know. Thank you.
Yeah.
This is Elise. Can you hear me?
Yes, I can.
Okay, wonderful. Well, first of all, thank you so much for doing this. This was super helpful. And I just wanted to comment that, we're doing a lot of remote pro bono really broadly in all our programs. And so we do have a few things that we found to be really useful when dealing with clients remotely during this time. One of which is that there are free apps that clients can download to their phones that help them scan documents. So to the extent that you need clients to send you supporting evidence, documentation, and it's difficult for them to mail hard copies, or they're concerned about not having a copy themselves and they don't have a way to sort of make a physical copy safely, they can download, I think the one we've used most frequently is Cam Scanner, and they can download it to their phone for free, and then it kind of does like a scan quality photo essentially. Obviously, if that's not an option, they can also take a photo of the document, but ideally you'd have kind of the scanned version. So that's just a tip I wanted to pass on to the teams, in case you're gathering evidence for your RFE responses.
That's great. I like that. Thanks, Elise. And so I'm curious, has anyone successfully video chatted with any of their clients?
This is Kristen. We have not, but we did have a psychiatric evaluation performed, and the psychiatrist was able to do a video chat with our client.
That's great. Did the client tell you how that went?
We haven't had a chance to touch base with her since the evaluation.
Yeah, that's okay.
But the doctor said it went fine.
Good. That's great.
Hey, Kristen, it's Tim. That sounds encouraging that you must have been able to get that appointment set up pretty quickly, huh?
Yeah. Erica actually found the physician and we kind of snuck it in because our deadline is coming up. So he was able to make some accommodations to talk to our client on a pretty rapid, quick turnaround basis.
That's good. Yeah, Erica, to answer your question, our client is not what we would call technologically savvy. No email, no text. So video chat is not going to be much of an option for us. Although we did tell the physicians nonprofit organization that you know, we would be open to a video evaluation, just like what Kristen's talking about, just because I imagine that might make it quicker to access, or you know, provide a broader pool.
Yeah. Yeah, and I recognize that not every client is going to be able to do the video chat, and I myself struggle sometimes with figuring out video chats. And yeah, so in that case, I would also remind the client that if they change their phone number, it's really important that they let you know that they've changed their phone number, especially during COVID, since that's your only way of communicating with her. Yeah.
Oh yeah, we've been through several phone numbers.
Yes. Yeah. Well, I guess any other questions or strategies or challenges that anyone wants to raise? Okay. Well, I think then we can end here. Thank you all for joining us today, and thank you again for your advocacy on behalf of survivors of trafficking. Again, we recognize that these cases are already really tough cases and have become tougher during COVID. So thank you so much for your dedication and commitment to your clients. Please do feel free to reach out to me with any questions, both for folks doing the initial filing and then also at the RFE stage as well. My contact information is here. And yeah, thanks again for participating.
Thanks so much, Erica.
Thanks, Erica.
Yeah, thank you.